What's up, everybody? We're back in the cave here to talk about Brian Kohberger. Some very interesting updates on some things we have been waiting for. And then a motion to see if Brian Kohberger and his team are going to start using some of this pretrial publicity in their favor. Maybe using is the wrong word, but at least embracing it, embracing the public interest, embracing transparency, which might indicate they think it would be in their benefit. We're going to talk about that. We're going to talk about what information the state actually does have to turn over to the defense, and if they were right there as well. And answer your questions, of course, in the comments. Make sure you leave them as we listen in the live chat or in the comments. I will try to be in there or check them out later and get to as many of them as I can as per usual. Make sure you don't forget to hit that like button and subscribe to our page. And let me know if you subscribed originally to our page because of this Brian Kohberger Idaho 4 case way back when it started. So the first document we're going to look at today is the public order for disclosure of IGG information. So what does this mean? Well, just from the order, it's telling me that this is something Judge wants the public to see, that in fact, he is going to rule the state has to turn over at least some of the DNA IGG information that the defense asked for, filed a motion to compel for, hired experts to testify about why it's important, and the state tried to block them at every turn for different reasons. Well, at least some of those reasons failed. Let's read this. On October 25th, 2023, the court issued an order addressing IGG DNA and order for in-camera review that addressed the state's motion to prevent disclosure of the investigative genetic genealogy information to the defense and the defense's motion to compel discovery of all information pertaining to the IGG investigation. So we all saw that hearing together, or at least parts of it, on October 25th. On November 30th, 2023, the state submitted to the court in camera all IGG information pertaining to the state's investigation from both the FBI and a private laboratory. So that means the state produced everything they had to the judge, and the judge reviewed it in camera or privately, not with the defense attorneys, but the judge reviewed it. And based on what the defense attorneys asked for, what they filed in their motions, the arguments that they made, the case law that they cited, the statutes that they cited, and the experts that they called at that hearing, and the judge has to do an analysis and a balancing act of what's important, what needs to be disclosed, what doesn't, what really has nothing to do with the case, what's irrelevant, what's protected, what's privileged. That's what the in-camera review is. So let's say he has 100 documents. He can make a spreadsheet and say document number 1 is this with this title. Yes, the defense should get it. Document 2 is this title. No, the defense should not get it. And probably with reasoning as to what he says yes to and what he says no to. Well, the court has now, from November 30th to, when is this? 11th day of January. So that's a pretty good turnaround for the court because this isn't his only job is this one case. So a little over a month. Even without the speedy trial deadline looming, the court did his job. He completed its review of the information provided by the state and orders the state to discover to the defense a portion of the IGG information. So the judge is ordering the state. So what it means to discover to the defense just means to hand it over. The state has now been ordered to hand over a portion of the IGG information to the defense. Well, what specifically do they have to turn over? The specific material to be provided is set forth in a sealed order to protect the privacy of the IGG information, including individuals on the family tree. I think that was a 100% appropriate and correct ruling by the judge. But it gives us a little insight into what must be discovered. right? At least some kind of information about individuals on a family tree, which we know is part of what the defense was asking for. So, what far reaching effects could this have on the case legally? Number one, the defense was at least partially right. They are entitled, at least in discovery, to part of this IGG information, for which the state said they should get none of. When we later on have the unfortunate discussion about whether or not Brian Kohberger's rights were violated and whether or not the state forced him to waive his speedy trial rights, if that becomes an appellate issue later or an issue at a motion later, this was one of the things I thought the defense might point to, that judge, we would have been ready if the state would have just turned over what even you believe they should turn over. They fought this IGG stuff tooth and nail. We had to file multiple motions. They didn't just discover it to us when we asked. We had to hire experts, and eventually you had to review all this. Delay. It was impossible for us to try this case within the speedy trial period because the state was blocking relevant material, discoverable material. Now, probably a losing argument because you're allowed to fight about this stuff, but an argument nonetheless that I expect we haven't heard the last of. Now, part of the IGG information does not mean all of it. So another motion we might hear from the defense is, we want more. We deserve more. The state's probably already filed its specific objections to the information, the part that must be discovered. So I do expect the state to turn over these parts the judge specifically sets out in a separate and sealed motion. But very interesting as this case continues to progress, signed by Judge on January 11th. Now, speaking of sealed documents, like the specific parts of the IGG information that must be sealed. Well, the defense has recently filed a motion to unseal defendant's motion to reconsider orders denying motions to dismiss the indictment, and in the alternative, for permissions to appeal from interlocutory orders. Comes now Brian C. Kohberger, by and through his attorney, Ann Taylor, hereby moves the court for an order to unseal the defendant's motion to reconsider orders denying motions to dismiss indictment, and in the alternative for permission to appeal from interlocutory orders and a stay of proceedings filed with the court on 12/21/23, and the state's objection to this motion that was filed with the court on 1/5/24. This motion is made on the grounds that the pleadings and hearing thereon do not need to be sealed. I'm surprised I haven't heard more about this in the public, because we know the defense and the state both agreed to try to keep cameras out of the courtroom and limit media attention and limit at least some public disclosure of what's going on, either documents, orally, arguments, grand jury proceedings, whatever it might be. But now, if the defense is moving off that line even a little bit, even just this much, they're moving to say more public disclosure, I would expect the media to get behind this. Previous motions related to the grand jury proceedings were properly sealed pursuant to ICR 32, Idaho Criminal Rule 6, and the court's order relating to grand jury proceedings. So we all agree that the grand jury stuff should be sealed. However, the pending proceedings brought by motion and supported by pleadings do not meet the language of the rule. What do they mean by that? The issues for the court to decide are procedural and legal and do not delve into areas covered by rule and order. So are they not mentioning grand jury specific proceedings, grand juror names? Instead, are they just saying you didn't pick enough grand jurors, or you didn't pick them from the right spots, or you didn't serve them the right way? Because this is really interesting to me, that basically what the defense is saying is, sure, the grand jury stuff has to be secret. We get that. That's got to be sealed. But the stuff we're arguing about does not fit into that stuff that needs to be sealed. Mr. Kohberger sought sealing of his filings solely based on email communications with the Latah County Prosecutor's Office stating they wanted the filings sealed. So Kohberger asked for them to be sealed in the first place. So why the heck would he ask for them to be unsealed now? Who knows? But I will say, legally speaking, if you specifically ask for a protection that the court grants, when you ask for it to be removed, why wouldn't the court grant that? Well, in this case, there were at least some discussions with the state and they want it sealed. So the judge is going to have to make this decision. The deadline for Mr. Kohberger's motion was imminent. Thus, in an abundance of caution, the defense filed a motion to seal. So basically they said to not cause delay so that the state would object and say this needs to be filed under seal, or to slow this process down. They said, fine, whatever, you want it filed under seal, we'll file it under seal so we get it in on the deadline. But now we're coming back and judge, it actually doesn't fit the rule. This should not be sealed. Counsel for Mr. Kohberger informed the Latah County Prosecutor's Office of a motion to unseal, that a motion to unseal was forthcoming. So the prosecutors are not going to be surprised when they see this. Mr. Kohberger moves the court to unseal the proceedings and filings on the basis that these filings and proceedings are not covered within ICAR 32. Mr. Kohberger acknowledges the right of the public to be fully informed of the issues. Oh boy. It sure seems like Kohberger's moving towards the side of let's have it out. Let's be transparent. Let's let everybody see what's going on. And from my perspective, I don't really know how much more it could hurt him. The public has already pretty much convicted Brian Kohberger. There are some factions that say he's absolutely innocent. It must be somebody else. But I think for the people in the middle, and there are some in the middle, that are waiting to see what happens in court, they see the evidence against Brian Kohberger. They see the issues with that evidence and proving this beyond a reasonable doubt, while also knowing that we don't know what all evidence the state has. We only know small portions that have been released. So there is some sort of middle position where people's minds aren't made up, even though it looks bad for Brian Kohberger. And it seems like Brian Kohberger, at least for them, and probably the factions that demand his innocence and his release, that you should see what's going on here. We need to be transparent. Stop sealing stuff that doesn't need to be sealed. And this fodder is something I thought when people saw they would run with. Because this is more than just let's unseal one document. When he puts a statement like this, Mr. Kohberger acknowledges the right of the public to be fully informed of the issues. That is not what they were saying when they were objecting to cameras in the courtroom. They did not, care, I don't know if that's the right word, but about the right of the public to be fully informed then, but now they do. What's changed? Mr. Kohberger has a right for the rule to apply as it is written, rather than disadvantage him with the items remaining sealed that are not within the scope of ICAR 32. So he just flat out says it. It is a disadvantage to Mr. Kohberger for these items to remain sealed. I mean, he's kind of building this up to me. I'm wondering what it is. What did they object to? What are they fighting about that's not protected under the grand jury rules? What could possibly be advantageous to him? Advantageous media reports about prosecutorial misconduct or something? Because that's not guaranteed to happen regardless of what is released here. But I am very, very interested. Is he talking about the IGG stuff? Probably not, because this is talking about stuff that's already happened in the past with his motions to dismiss the grand jury indictment that we've kind of seen pieces of and gotten context of, but not the full thing. I am very, very interested to hear the judge's ruling. I hope the judge does unseal it, because this stuff should be public unless rules say it must be sealed. And we always talked about the number one person's rights we don't want to trample on with public interest and media attention is the defendant's rights. Because let's be honest, most of the time it's negative reporting for the defendants. So if he is saying it's a disadvantage to have this sealed, he thinks this should be unsealed, The only person that wants this sealed is the prosecutor because it's bad for them, basically, is what it sounds like. I think the judge should unseal this. Now, I'm saying that not knowing what it is, and that's probably jumping the gun, and the judge will have to weigh it. And if it actually is part of the grand jury proceedings, that must be secret, and Kohberger wants it to be unsealed, because that ain't going to happen. But I'm really interested now. This motion quietly got my attention. I want to know what you all think, as usual, in the comments. Are you surprised at this? Why do you think Kohberger wants this unsealed? What do you think could possibly be in there? A lot of you do background research, Reddit research, sleuthing, and know all these, theories that I don't know about. So let me know what you think in the comments. I'll read through them and see what I can conjure up to see what makes most sense, if anything. We'll probably have to wait and see what exactly gets unsealed. But I sure am interested, and I appreciate you guys joining me. Hit that like button if you haven't already. Subscribe to the channel so you don't miss any future videos or discussions. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.